Hi, everybody. Welcome to the next of the AFP policy series. We're going to go ahead and give just about 30 seconds as people are starting to join and roll here into our event today. So we'll give it just a few minutes and go from there. I'm sorry, about 30 seconds. We'll go ahead and get started. Folks, we're giving it just a few more seconds to allow some folks to join. It's good to see everyone joining us today. We'll get started here in just about 15 seconds. All right, well, there are still folks joining us, but we're going to go ahead and get underway. And first, my name is Brent Gardner. I'm Americans for Prosperity's Chief Government Affairs Officer. And I'd like to welcome you to the next in our policy series, talking about topics. And today, it will be on the financial regulatory space. For those of you who are not aware of AFP and who we are primarily a grassroots organization. For those of you in DC, you probably know us from having joined you in your offices and talking about issues that are critical to our grassroots activists across the country. Millions of activists in all 50 states engaged on a range of issues. For many of you, you've either worked with AFP in the past, or hopefully this is a great opportunity to spark a chance to work together on many of the issues that we talk about today, or really issues kind of across the spectrum. So if today you're here to kind of whet your interest and there's additional thoughts that you have on policies that you'd like to pursue, we'd look forward to trying to have some opportunities to talk to you here in the near future. But today, the focus of today's conversation will be within the financial regulatory space, particularly within the regulation of our capital markets. As you know, raising capital is critical for businesses to scale and grow their operations and to compete in providing goods and services. However, this has not always been an easy task for entrepreneurs to get access to funds, and regulations out of Washington, D.C. have certainly played a major role in that. Recognizing the critical importance that these markets play in our economy, AFP has become increasingly engaged in these issues and is seeking opportunities to help support job creators with the right regulatory framework that will help them thrive. To lead today's conversation, I'm excited to hand this off to our MC for today's event, our Senior Federal Legislative Liaison, Matthew Silver. Matthew?
Thank you, Brent. As mentioned, my name is Matthew Silver, here with the Federal Government Affairs team at Americans for Prosperity. I cover the financial services portfolio for our team, and I'm very excited about today's panel. We've got a great panel lined up for today's conversation. So I'll go ahead and introduce our experts. First, we have Clint Woods. Clint is our policy fellow at Americans for Prosperity, where he focuses on regulation and environmental policy. From 2017 to 2019, he served as the Deputy Assistant Administrator for Air and Radiation at the U.S. Environmental Protection Agency, and previously worked as Executive Director for the Association of Air Pollution Control Agencies. Next, we have David Burton with the Heritage Foundation. David is the Senior Fellow in Economic Policy at the Heritage Foundation's Rowe Institute for Economic Policy Studies, where he focuses on, among other issues, securities regulation, tax matters, entrepreneurship, and business law. Prior to Heritage, David has held several roles in the DC area, including General Counsel at the National Small Business Association, Chief Financial Officer and General Counsel at the Alliance for Retirement Prosperity, and partner at the Argus Group, a law, public policy, and government relations firm. And finally, we have Andy Vollmer, who is the Senior Affiliated Scholar at the Mercatus Center. Andy previously taught securities regulation from 2014 to 2019 and was the director of the John W. Glenn Jr. Law and Business Program at the University of Virginia School of Law. For many years, Andy was a partner in the securities litigation and enforcement practice of Vollmer, Cutler, Pickering, Hale, and Dorr, and he served as the general counsel at the Security and Exchange Commission from 2006 to 2009. So again, really excited about these panelists. They have a great wealth of experience. Just two quick housekeeping items before we begin today's conversation. The first is at the end of our conversation today, we'll have a chance for you to submit anonymously your questions for our panelists. So I believe in the right-hand bottom corner of the chat, you should be able to type in your questions. Please go ahead, as these questions come to your mind, go ahead and type them in so that we'll have them teed up for the Q&A portion. And second, also dropped into the chat as well, you should have perhaps received it in your email if you registered early with us, is a document, AFP's Financial Regs Timeline. I wanted to kick it over to Clint Woods to share a little bit about what that document is and how it might be helpful to you and to your member. Clint?
Absolutely. Thanks so much, Matthew and Brent, for organizing this, and really excited about the conversation. Really excited to be joined by Andy and David, real experts in the field, and thought just kind of to set the table a little bit. There's a number of topics, a number of particular financial regulations that we're going to be talking about that we may see in the not too distant future from the Biden administration. Some that are also paralleled with legislation that we've seen either recently passed or that Congress may be looking at in the not too distant future, and thought it might be helpful to just share a little bit of a landscape of what may be coming down the pike. And I guess just to step back a little bit, as Brent reflected on a little bit, Americans for Prosperity strives to create an economy that works for all, to empower people to earn success and realize their full potential. We find that often top-down government solutions, including in the financial space, can often shrink that access to capital and undermine the really important first steps that families and entrepreneurs and farmers and business owners need to make their dreams a reality. And many times those same policies disproportionately impact lower income individuals, smaller businesses, startups. And so we really want to push for reforms that fundamentally and structurally change the way the federal government currently is approaching facilitating access to capital, facilitating capital markets. And so we think there's quite a bit on the horizon that's of concern. So the timeline that we've linked there, that PDF document, we've done this on a few different topics in the Biden administration. I think we realized starting on day one, the administration was going to hit the ground running. And for a number of regulatory topics, executive branch actions, implementation of international treaties, there's a ton going on. So this is just an attempt to kind of take a snapshot of, as of right now, what we see coming down the pike. So we took a look at several executive orders issued by the Biden administration, starting on the first day in office in January and continuing through the last few weeks. That includes executive orders on climate-related financial risk, recent one on promoting competition, several on climate change, as well as economic relief resulting from the COVID-19 pandemic. We also took a look at several interagency memos that also provided additional direction to federal agencies, as well as the Spring 2021 Unified Agenda. So this is a document produced by agencies, but overseen by the Office of Management and Budget that really catalogs both regulatory and deregulatory actions, gives a little bit of an excerpt of what they plan to do and when they plan to do it. So it gives you a pretty useful snapshot of what agencies like the Securities and Exchange Commission and agencies within the Department of Treasury may be looking to pursue. I think there's a couple themes that stick out. Don't want to dwell on any particular regulatory action or reporting requirement, but just a few things that jumped out to us from this list. One is this is a really aggressive administration. They're doing a lot in the executive branch. There's a ton coming down the pike. There's some themes that we saw, and you've seen perhaps on other topics that you work on or other agencies that maybe your boss is interested in, a heavy emphasis on things like environmental, social, and governance goals, and climate change is a cross-cutting issue, even for agencies that traditionally have not engaged in that space. Similarly, a really high level of coordination, an attempt to coordinate efforts across the government, installation of new czars and task forces and competition councils that may or may not fly in the face of the limited statutory authority that Congress has given to those agencies to implement the law. Similarly, those new bodies may create opportunities for your boss. So we've included in there in italics several of the reports and interagency activities that are happening or will be happening in the near future that may be a good opportunity to ask for things from agencies in your oversight role. There's also a number of proposed rules. Several of them are to counteract and attempt to durably revoke Trump-era reforms, a number of actions at SEC that we'll get into a little bit later. There's also substantial overlap with some of the majority's agenda when it comes to legislation. In my mind, that is kind of an attempt, a recognition that perhaps there isn't existing statutory authority for SEC or the Commodity Futures Trading Commission or other agencies to implement some of the things the Biden administration wants to. But you'll see quite a bit of overlap on things like gamification and short sales, board diversity, ESG and climate risk disclosure, proxy voting. And I think the other lesson to take away there, in addition to the goal of kind of de-risking that administrative state approach by potentially passing legislation, we think you should defeat that bad legislation, but that's probably necessary, but not sufficient. So we'll talk a little bit later about some of the tools that you and your boss may have to exert some pressure, force votes on some of these tough issues, and potentially expand your oversight role as it relates to actions that are going to take place in the Biden executive branch. Finally, just to kind of reflect on, I think, what this timeline represents and hopefully what this discussion is going to point us towards, I think David and Andy are the perfect people for us to be thinking big picture and long term about future Congresses, about structural reforms, about the need to revisit outdated statutes that ultimately give authority to federal agencies to implement some of these requirements. Secondly, I think it's really important that we defeat bad bills. And there's a lot of reasons, and I think a lot of things that will be articulated on this call as to why top-down policies, one-size-fits-all approaches are really the opposite of facilitating efficient markets. And third, finally, just to explore a little bit, I think we'll do this towards the tail end, about the tools in the congressional toolbox to potentially provide that oversight that we think is absolutely critical of the runaway administrative state, and really expansive view of what executive branch agencies can do in the ESG space, and when it comes to a number of these topics. So that's kind of a high-level overview, and happy to dive into any of the particular items. Just wanted to kind of introduce that document. Hopefully it's a helpful resource for you and your boss.
Thank you so much for that, Clint. I think that is a really helpful 1,000-foot view of the full sweep of financial regulations coming down the pipeline. As Clint sort of referenced, I think in addition to addressing these very specific pieces that we're going to be focusing on within the SEC's regulatory agenda, I think this conversation will also help provide some useful context for long-standing barriers to access to capital for business owners that have exist, notwithstanding what the SEC is going to be considering doing in the near future. And I think just given the incredible burden that businesses themselves have borne during the COVID-19 pandemic, and as we think about what our economic recovery looks like, this will be critically important for members and their staff to think not only how they can oppose these regulations that are going to be coming out, but also thinking towards the future of what a proactive agenda might look like in breaking down these barriers to capital. But with that, so today we're going to be talking about both public and private markets. I would like it if David Burton could set the stage for us in providing an overview of the current state of capital formation in the United States, both for public and private companies. So David, what are the current challenges that private and public businesses face when attempting to raise capital in the United States? And what does this mean for growing businesses here in the US?
Well, there are a lot of problems. This is an area where there were some substantial improvements in 2012 with the Jobs Act. But let's sort of start at the beginning here. The general rule is you have to register with the SEC, i.e. go public, unless there's an exemption. And going public has become extraordinarily expensive. The SEC itself estimates that it costs about $2.5 million to go public in lawyers and accounting fees and underwriting fees and so on and so forth, and something on the order of $1 million a year to comply. And that's an average. It varies, obviously, but it's something that's extraordinarily expensive, and for a small, medium-sized firm, not really an object. And you see that in terms of the number of listed companies having declined by almost half over the past 25 years. And the fact that companies go public much later in their life cycle. So the Facebooks of the world are going public after they've already achieved large size. In the old days, so to speak, entrepreneurs could raise money to grow their businesses at a fairly early stage in their life cycle. That's no longer really an option, and that's a function of the ever-increasing regulatory burden on public companies. Now, the good news is that the private markets have stepped up to meet the need of entrepreneurs. Regulation D in particular is a safe harbor that gives definition to what constitutes a private offering. And Regulation D allows businesses to raise something on the order of 1.7 trillion with a T dollars annually. So probably one of the most important things to remember is that in terms of entrepreneurs getting off the ground, Regulation D is the key. The bad news is that Regulation D and reforms to it are on the Biden uniform agenda. So they very well may be trying to attack that form of raising capital. And there's a couple of different ways that it's likely they'll do that. Prior to the 2016 election, progressives were pushing to radically increase the thresholds for what is an accredited investor. An accredited investor is someone who basically can invest in Regulation D offerings and not trigger any additional regulatory requirements. It basically means financial institutions or individuals that either have a joint income of over $300,000 or a residence exclusive net worth of over $1 million. So fairly affluent people. Depending on whose math you look at, roughly 10 to 13% of the American public currently meets those definitions. Prior to the 2016 election, the progressives were pushing to radically increase those thresholds to something like $700,000 a year in annual income and potentially more, and a net worth requirement of over $2.5 million. In effect, they want to retroactively increase the thresholds to account for inflation since 1982 when Regulation D was put in place. So that would reduce the percentage of the population that can easily invest in Regulation D offerings from roughly 10 to 13% of the population to 2 or 3% of the population. So it's a radical it radically reduces the number of people who can invest in private placements. It radically reduces the number of people that entrepreneurs can seek out as potential investors. And it basically sets up a situation where only rich people can invest in private offerings under Regulation D. That's undesirable for a whole host of reasons. One is it means that ordinary people will no longer be able to invest in these companies when they're growing and making the most money. It also means that entrepreneurs in middle America will no longer know any accredited investors or only know a couple, and therefore basically be unable to find investment capital unless they pay large fees to broker dealers in New York or California. There's also some problems with the Jobs Act that really need to be fixed. For example, you've probably heard a fair number of people talk about equity crowdfunding. Equity crowdfunding has been, shall we say, an extraordinarily limited success or really a failure. And the reason for that is what the Senate did to the Jobs Act, Title III of the Jobs Act. There's tremendous number of regulatory burdens imposed on these companies that up until quite recently could only raise $1 million using Regulation CF. There's audit requirements, there's disclosure requirements that are fairly close to the disclosure requirements imposed on smaller reporting companies in the public market space. It's no mystery that it really hasn't worked very well. There's also tremendous burdens imposed on funding portals that are the web platforms through which these investments are made. About 60 million with an M has been raised annually using Regulation CF. Compare that to 1.7 trillion that's raised using Regulation D. So, I mean, it's just night and day. And that's unfortunate. And there are changes that should be made to Regulation CF. There are changes that should be made for Regulation A, which is sometimes called a mini IPO. Regulation that basically killed Regulation A as a meaningful, literally, as a meaningful way of raising capital prior to the Jobs Act. The Jobs Act increased the thresholds, and recently the SEC did as well, and made some other improvements to it so that now it's a plausible way to raise capital for fairly robust entrepreneurial firms, and it's starting to have a meaningful impact. If memory serves me correctly, roughly $500 million was raised using Regulation A. But there's a whole series of things that we need to do to reduce the regulatory burden on entrepreneurs seeking capital and to democratize access to these high growth companies for ordinary Americans. There's a lot of things that can be done, but the thrust of everything the Biden administration is proposing, or the Biden SEC, is to make these situations worse, not better, and to restrict access to investments, not democratize them, to make it harder for entrepreneurs to raise capital, not easier.
Thank you for that, David. That was quite the overview. I'd like to focus in on one of these particular threats, which is what is called environmental social governance metrics, or ESG. We've referenced it, but Andy, I'd like to kick it over to you. Can you just simply tell us what is ESG and how does this kind of rulemaking compare to what we've seen from the SEC before, and how is it actually a departure from the framework that we currently understand with public company reporting?
Thank you, Matthew. I'm happy to be here and talking about these subjects, and it's what I spend a great deal of time on. First up, smallish point, just to correct, I was the Deputy General Counsel, not the General Counsel at the SEC. So first, let's describe a little bit, very briefly, about ESG. I think most of you are probably familiar with it. But then to get to the second part of Matthew's question about how would ESG, or I'm going to concentrate, by the way, on climate change disclosure issues rather than the broad reach of ESG, and you'll understand in a moment. So ESG is environmental, social, and governance. It's got a very wide application. It's aimed at for-profit companies. And in general, it means that corporations should act to benefit groups other than the shareholders. So groups such as the employees, suppliers, and the community at large. So corporations, according to the ESG movement, should advance general social purposes and not simply seek profits. So corporations should fight climate change. They should protect jobs. They should increase diversity in the workplace. Those are some of the leading areas of interest to ESG proponents. It's a very wide area. It's very broad. It, I think, suffers from vagueness and a lack of clarity. It's also turned into a heavily political area. Many of the debates overlap with partisan politics. And what you see often is advocates for ESG outcomes using procedures that bypass Congress and legislatures to achieve those outcomes that they probably could not obtain through the legislative process. So I think that's of interest to you and your members. Many groups use ESG as an end run around democracy. So the second part of Matthew's question was, as I told you, I'm going to concentrate on climate change disclosures because that has been at the top of the agenda for the new SEC led by Chair Gensler. So would mandatory climate change disclosures be a departure from the current reporting structure that the SEC uses and requires public companies to meet? Climate change disclosures would differ in critical ways from the current main disclosure obligations. And before I identify a couple of those fundamental differences, I want to make this point because I think it's potentially very important to you and the members of Congress. Because climate change disclosures are so different from the standard disclosure obligations at the moment. The argument is strong that the SEC does not currently have statutory authority to adopt rules requiring climate change disclosures. The SEC needs further permission in the form of legislation and direction from Congress. So, such as there's an effort in HR 1187. So those of you on the House side probably know about that. The House passed it and sent it to the Senate. It's currently before the Senate. So that would, in fact, be further congressional action. That bill has a lot of problems, and if we have time, let's talk about that. But I think that you and your member need to be concerned about the plans at the SEC to adopt climate change rules, disclosure rules, without having the necessary and appropriate congressional approvals. And the members should look for opportunities to express their concern to the SEC commissioners. In our system, we do not want the SEC acting on its own until Congress has made the important policy decisions. And we do not want the SEC to act on its own if Congress is not able to reach agreement and pass new legislation. Agencies are not supposed to decide on the important policies for the country. If agencies originated the law, we would have government by unaccountable bureaucrats. And that's autocratic, and that's not the way our system was set up. So this is a matter of some urgency. Unless told to stop, the SEC is highly likely to adopt mandatory climate change disclosure rules. And what the SEC does will limit and affect what Congress could do to take a different approach. I'm working on a paper at the moment to explain that the SEC does not currently have statutory authority. It's not quite ready for release. But if this is an area of interest to a few of you, and you're interested in briefing your member and possibly having your member express concern in some way to the SEC commissioners, I'd be happy to brief you orally. And so just we'll figure out a way for you to indicate interest. You can get hold of Matthew, or of course, contact me at the Mercatus Center.
Thank you for that.
Time, Matthew, and let me know if I have more time, but if you want to move on, also let me know about that.
Yes, we do have a few more questions, but thank you for that, Andy. I think we'll be coming back with Clint here in a little bit in terms of other ways in which members and their staff can get engaged in something that I think Americans for Prosperity would be certainly able and willing and delighted to help with members thinking about how they might be able to engage. I think that's really helpful in setting the stage for what these ESG requirements might look like. As David has talked about, there is a huge compliance cost with companies going public and staying public, very burdensome. David, can you talk a little bit more about what the actual impact of an ESG metric or standard would be on the actual businesses themselves, their day-to-day operations? And what does that mean for the future of public markets?
Well, if you read the progressive literature on ESG, it is very inconsistent. It depends on the author, but there's an almost limitless taste for imposing additional disclosure requirements on public companies. And in point of fact, some of them realize they're killing the public market, so they need to start imposing this on private companies as well. But it falls into different categories. There's climate change, there's diversity and inclusion, which really means the opposite. And then there's various corporate governance type initiatives that they have in mind as well. But let's start with climate change. So every public company would be in principle forced to determine the impact on the issuer, i.e. the company making the 10Ks and the 10Qs and the 8Ks of climate change into the distant future on their company. So they have to, first off, become experts on climate science and decide which climate model they're going to adopt for purposes of their disclosure. For those who are familiar with that, you know that there's tremendous variance even within the government models, and once you move past the government models, tremendous or even greater variance. Then you have to decide what the overall macroeconomic impact of, quote, climate change is going to be. And there aren't any very good models on that. And the ones that sort of make guesses about it have vast differences in terms of what they project the economic impact is going to be. So you have highly uncertain climate models on top of which are built even more uncertain economic models. Then they need to make a guess about the impact on the issuer. And they need to make guesses about how the markets are going to respond to these various economic and climate effects. So you have a guess built on top of a guess, built on top of a guess. And they're going to have to develop some level of expertise on all of that and then make their guess. And then they're going to be, your filings with the SEC are subject to review by the SEC, but they also can give rise to private litigation. So when your guess on top of a guess on top of a guess is wrong, which it almost inevitably will be at some level, you're going to end up getting sued for having been wrong and made materially misleading disclosures. It'll be an unmitigated disaster, but it will definitely do one thing to help a certain class of person. Lawyers, accountants, economists, and compliance officers that have to advise public companies on these subjects will do extraordinarily well. And, you know, if you make even just slightly modest exceptions, you're going to create a multi-billion-dollar industry in climate change disclosure compliance. And those people in turn will lobby for an even more complex system, and certainly in the maintenance of the new system. You're going to have similar things going on with respect to diversity and inclusion disclosure, pay disclosure, you know, and so on down the line.
Thank you for that. That's really helpful, David, and really concerning to think about how burdensome this will be, especially given, as you've helpfully laid out, the already tremendous burden and difficulty with companies being able to participate and offer securities within public markets. Before we move on, I do want to remind everyone, if you do have questions, please do go ahead and submit those. We'll be coming around shortly to our Q&A portion of the conversation. But I think, Clint, maybe did you have something to add on this point?
I was just going to add, I think David summed that up really well. The one thing that I'd mention, and as a couple of Andy's colleagues at the University of Virginia put it in their comments to SEC, the SEC has neither the expertise nor the political accountability to pursue climate, diversity, or other public policy goals. And I would just say that extends to not only considerations around the physical impacts of climate change and that climate change risk disclosure industrial complex that would develop, but even questions as to how emissions and markets respond to regulation or taxes. As you've seen over the last 15 years, the United States has reduced greenhouse gas emissions more than any country on earth, despite the absence of federal policy or signing up until very recently with the Paris Agreement. Similarly, at the state level and other subnational levels, everybody who has adopted top-down carbon taxes, cap and trade programs, renewable energy mandates, there's virtually no relationship between those policies and progress when it comes to reducing a wide array of emissions. So even at the level of, you would kind of assume there was a relationship between climate policy and potential impact that may need to be disclosed. But even at that level, I think there's a very strong argument that SEC and other financial regulators lack the ability to meaningfully explore those disclosure requirements on public or private companies.
climate disclosure under Regulation SK is like a triple bank shot. It's, the odds of it having any effect are genuinely trivial. It's one thing if you impose a regulatory rule at the EPA saying you can't do X to emit substance Y, but to have a company make a guess on a guess on a guess on a guess and then disclose it in its securities documents isn't going to do anything other than hurt the public markets and reduce access for ordinary Americans to investing opportunities.
Another aspect of this that I'd like it if we could touch on, Andy already mentioned this bill, HR 1187, this very large SEC disclosure bill that included, exposure to greenhouse gas emissions, a whole host of other issues within the social and the governance side of it. One of the provisions that really stood out to me of particular concern is the standing up of this advisory panel that would basically tell the SEC about certain policies that should be adopted in order to steer capital flows towards what they called environmentally sustainable investments, which I think the issue here is really government setting preferences for particular industries and companies. We'll start with Andy. Could you talk about the proposal related to that bill of this advisory committee? Could you talk about both the committee and also ESG metrics more broadly, how that could exacerbate a problem of government tipping the scales for winners and losers of who should get access to capital? Could you talk about that, Andy?
Sure. So this advisory committee that Matthew mentioned is in Title I of the bill. The bill's got 6 or 7 titles. And the provision he mentioned, setting up an advisory committee to come up with recommendations to aim investment towards environmentally sustainable investments, has the problems that Matthew mentioned. You've got government intruding into the allocation of capital and skewing market decisions. There are a couple other problems with Title I. First of all, it overlaps with Title IV. Title IV is a far more extensive, detailed, and specific set of climate change disclosures. So there's no reason for both Title I and Title IV. Look at that if this bill ever comes up for your attention. Another problem with Title I, which sets up this advisory committee, and the provision that Matthew mentioned, is it reveals one of the real objectives of climate change disclosures, which is not, although some people purport this to be an objective, it's not really to have companies explain how their personal financial situations being affected by climate change developments. The true objective of the climate change disclosures is to set up for certain influential groups the ability to affect the performance or behavior of specific companies. It's to allow the public to impose pressure on certain companies to either reduce fossil fuel emissions or to be more aggressive in addressing climate change problems. That, by the way, is an example of why you don't want the SEC to be imposing climate change disclosure obligations on its own, but it also is something that all the members of Congress need to pay attention to if they start to consider this bill. They should be convinced that the disclosures are likely to produce benefits. David's already commented on the remoteness of the climate change disclosures and the kinds of results that people are trying to achieve. So, but that's the point. You need to try to figure out what's the objective of the bill And is it likely to achieve a realistic benefit at an acceptable cost? So there needs to be a cost benefit analysis, even at the congressional level, about these climate change disclosures, because the costs of the disclosure would be enormous. And as we started out with Matthew's question, those disclosures are likely to distort the allocations of capital.
Let me just add one thing. We're talking about the SEC, but this is going to be occurring in virtually every financial regulator, particularly the banking regulators. And two colleagues of mine and I recently published a paper called Using Financial Regulation to Fight Climate Change. And it walks through a number of the banking regulations as well, and how those can be exploited to allocate capital to achieve progressive ends and to harm investors and industries that the progressives don't like. So this isn't going to be just the SEC. It's going to be the Federal Reserve, the FDIC, OCC, and so on down the line. And there's very little doubt that they're going to try to allocate capital towards green initiatives and away from fossil fuels and other disfavored industries that may or may not have anything to do with energy or climate. Think, for example, firearms manufacturers. So the long and short of it is that this is just one aspect of it. And if you look at the Biden executive order, they basically have instructed every agency in FSOC to make recommendations by November on precisely how they can do that to influence capital allocation to achieve progressive ends.
Yeah. Well, these are some very concerning proposals that I think will dramatically reshape our capital markets for the worse and ultimately harm American businesses, workers, and retail investors. Given what's at stake for our economy, I think it's really important that members of Congress and their staff are prepared to respond to these regulatory developments. Clint, you've kind of already walked us through the financial regulatory timeline, but you had some additional thoughts about how Congress might be able to proactively counter some of these proposals and provide some oversight. Could you share some of that?
Yeah, absolutely. And want to make sure, because I'm certain that Andy and David, as longtime practitioners and experts, probably have a lot to add as well on how members of Congress can be particularly effective. I'll just say, for broader context, it's probably something that it doesn't need to be said. But one of the reasons that I think response to executive branch efforts in this space is incredibly important is because a large portion of traditional allies and large swaths of the private sector is scared of these issues. And so more so than almost any other issue, I know we're having a lot of big debates on a number of different public policy topics and really asking questions about the role of government, certainly, but also the institution of business. I think the nature of these actions are one where probing, asking about process, looking at the limited authority that Congress has given to executive agencies to achieve certain goals that do not change based upon the political winds, I think are really, really important in some of those themes that Andy and David had articulated. I think similarly, a lot of these activities are going to not only be promulgated via executive order and regulatory agency notice and comment rulemaking, but also keeping in mind that a number of institutions like NASDAQ are self-regulatory organizations who under the Securities Act have been imbued and deputized to carry out some of these functions, may seek to ask SEC to bless certain activities or requirements that they want to impose on folks who participate within their exchanges. And so it may be a slightly different process, but ultimately is all about Congress has given its lawmaking authority to a federal agency that has in turn given it to a quasi-public entity. And so I think asking important questions about where that line is drawn and focusing on the ways in which unaccountable governmental agencies need to be held to account is incredibly important. So to that end, I think there's 3 tips that I would suggest. One is write a letter, submit a comment, get your boss to a public meeting. This is really important. I know sometimes it doesn't seem that way when you go and check out an SEC regulatory docket or regulations.gov and you see thousands of comments. I can tell you, as you know, having worked at one of the real engine rooms of the administrative state, comments matter. Comments by members of Congress who are on committees of jurisdiction, the Appropriations Committee, leadership, it doesn't matter. They go to the top of the pile. And my suggestion to you would be two things. One, you should send a comment saying you do not have statutory authority to do the thing that you're proposing to do. And I know Andy and David both probably have a lot more thoughts on that, but executive branch agencies, when they see congressional letterhead with questions of statutory authority, think twice. Secondly, ask for things. So that timeline we circulated had a number of items in italics that are reporting requirements, interagency coordination, new councils. Those are all things that, frankly, those agencies don't really want to give out until they're a finished, refined product. And it makes their life much more difficult if members of Congress and the public through the FOIA process are asking for those documents. Similarly, you may want to explore your committee rules, and you may have oversight abilities even in the minority. I know, for example, the House Oversight and Government Reform Committee, a minority of members asking for certain documents can prompt the compulsion of those documents to the committee. The second thing is coordinate. As you can see from that timeline, there are dozens of actions upcoming. There are a lot of them that are really bad. And ultimately will result in less efficient capital markets, a less robust economic recovery out of this pandemic, and your boss can be a champion on several of them in all likelihood. So thinking about coordinating with other offices, with the other chamber, if you're looking at legislative solutions, with committees, and don't forget about your states. We're already seeing state attorneys general and governors are uniquely situated to challenge some of these federal regulatory overreaches. For example, West Virginia's attorney general and state treasurer have already gone on record saying SEC's climate risk disclosure is one of the top threats, and we expect to challenge it in any way that we can. And the third tip, I think, is there are very few abilities to force votes in the House or Senate, but three tools that you may want to think creatively about that agencies pay very close attention to. One is the appropriations process. So anything that you can do to, for example, provide at least a shot across the bow at agencies that may be creatively using taxpayer dollars to implement top-down solutions and climate risk disclosures and changes in the regulatory process that your boss disagrees with, they'll notice. Second is the budget resolution process. So in the next couple of weeks, as part of the reconciliation for infrastructure, we'll see a vote-a-rama process for the Senate budget resolution. Long story short, I think many of you probably are familiar with that, but an opportunity for rapid fire votes on issues that probably at least 50 senators don't want to touch with a 10-foot pole, but where you may be able to get Congress on record opposing some of these efforts. That seems like a really, really valuable opportunity. And the last one, which we can talk about further, but we also may have some more resources to share, is going on offense through using the Congressional Review Act of 1996. So you all are probably familiar. There's been, I think, three rules that have been invalidated in the last few months from the tail end of the Trump administration using the Congressional Review Act, under which all rules broadly defined have to be submitted to Congress and ultimately provides for an expedited process for Congress to invalidate those rules. The broad definition, which has been given a little bit more meaning by some actions by Congress, as well as weighing in by the Government Accountability Office and the Office of Management and Budget, includes guidance. It includes a number of the shortcuts and the short circuit ways in which the Biden administration has pulled back some reforms. So just to give you one example, towards the tail end of the Trump administration, a rule was issued as it relates to ERISA. So this was a Department of Labor rule to try to propose and ultimately finalize regulatory language related to the incorporation of ESG for private pension plan managers. That went through a full rulemaking process, finished in plenty of time, and the Department of Labor under the Biden administration issued a memo saying we're not going to enforce that. I think there's a very legitimate argument that that is a rule under the Congressional Review Act that Congress could ultimately review and invalidate with a bare majority. So just to say out loud, under the CRA, you only need 51 votes. I don't think President Biden will probably sign anything that ultimately gets adopted to invalidate his administration's rules. Having said that, in the United States Senate, with only 30 votes, 30 senators signed on, you can expedite the process, get a CRA resolution of disapproval, which could be anything on that timeline, and force a vote and 10 hours of debate. And while ultimately that may not succeed, it is one of the few tools I think members of the minority have to ask important questions about what the executive branch is doing, and ultimately get those questions to the floor of one of the two chambers of Congress. And so thinking creatively about going on offense, I think will also make those agencies think a little bit more carefully about some of the breakneck pace and whole of government approach that they're pursuing in this space. So those are kind of the suggestions that I have, but also want to make sure we leave plenty of time for Andy and David to share their thoughts on how to potentially push back on these efforts.
Just a couple of quick thoughts. First off, joint letters from members of Congress where, for example, there was a letter against the NASDAQ board diversity rule, which is really affirmative racism on the part of NASDAQ, requiring that member companies discriminate on the basis of race or ethnicity. There was a letter that every Republican member of the Senate Banking Committee signed, and that has to give the SEC some pause when they're considering whether to do that. So to the extent you can sort of develop a consensus and issue joint letters in this comment process, that makes sense. And I agree that members of Congress filing comment letters can be extraordinarily important. The other thing that I think everybody should be thinking about is developing a proactive reform agenda now, with the idea that if the Congress changes hands in the midterms, that we can start we're already ready to go in terms of proactive reforms, instead of waiting until the elections occur and then so it's like, oh, we won, now what do we do? Well, we should never have a repeat of what happened after the 2016 elections, where it took well into the second session before meaningful reform legislation was being dropped. We need to be ready, and that means we need to start thinking through constructive, positive reforms now, not a year and a half from now. And there's a long list of things that we could do that are constructive.
With that, Andy, I would love, as our final question, do you have any thoughts on just one or maybe two reforms that you think would be most impactful as part of that proactive agenda that David mentioned?
I do. Here are my leading items. I agree with David that the public offering process, that's sort of the standard main method that the 1933 Securities Act developed, so call them public offers, has really become broken. It is enormously expensive. There is an extremely detailed and burdensome set of disclosures that needs to be made. I think that can be reformed, streamlined. Congress, by the way, has tried to get the SEC to move to reduce the disclosure burdens, but has not been successful so far. So Congress ought to continue to press forward on that. Also, there are a set of extraordinary restrictions on the companies who are engaged in public offerings, including gag orders. There are restrictions on speech that the regulations and the Securities Act impose on companies engaged in a public offering. There's no need for those. They're not justified any longer, even if they were justified in 1933. So first big item, let's reform the public offering process and make it work, because that leads to a democratization of share ownership. Public offers are open to everyone. So my two other ideas are, we need a new form for private offerings. The private offering system under Reg D is extremely valuable. We don't want to lose it, but the whole category of accredited investors is a failed concept, and it can be changed. Congress probably would need to do it. And the third idea is we need a micro cap offering exemption from the public offering process.
Thank you for that, Andy. And thank you all for your insights. That's all the time we have for today. Thank you to our panelists for sharing their comments. And thank you to our audience for attending today's event. We at Americans for Prosperity as well, I'm sure our other panelists stand ready to help assist you and your members as you continue to work on these issues. And we look forward to staying in touch with your offices. Thank you again and have a great rest of your day and week.